Hi there, I'm digital anchor Brandi Smith. The leak of a draft majority opinion from the Supreme Court that would overturn Roe v. Wade is generating a lot of questions about the leak, about the opinion, and about the impact it might have if the draft does reflect the court's final decision. To answer some of those questions, at least the ones that can be answered at this point, we've brought together constitutional law professors from here in Texas. Josh Blackman from the South Texas College of Law in Houston, Seth Chandler from the University of Houston Law Center, Lucas POWE from the University of Texas Law School, and LYNNE Rambo from Texas A&M's School of Law. I want to start off by getting your reaction to this draft. And Professor Rambo, I'll start with you.
Well, certainly the first reaction was one of shock. It's never been done before. That's about all I could think. That I was, at least that I was aware of, and I'm still unaware of any time an opinion has been leaked. The second was a certain reaction to the content of it. I was not at all surprised about the content of it in terms of it planning on overruling Roe. It's hard to have been around, and particularly to hear the oral argument and not expect that that was coming. So I guess those were my first reactions. And then your thoughts turned to who would have done it.
Professor Chandler, your first thoughts?
Yeah, I too was shocked by the leak. My initial reactions were thinking about the implications of the decision if it remained as drafted, both on reality and the ground here in Texas and other states, which will have trigger laws that will start to make abortion a felony within a month of the opinion coming down, as well as the battles that are likely to be occurring in the future in Congress, state houses, and state courts about the future of abortion law. Because although this opinion is a big deal, it's not the end of the story.
Thank you, Professor Chandler. Professor POWE, what was your first reaction?
Like the others, absolute shock. And then after I was dealing with the shock, it was how could somebody breach their ethical duties so blatantly?
And Professor Blackman, you're up. What were your first thoughts when you saw this news break last night?
My biggest concern went to trust. The judges on the Supreme Court need to trust each other to do their job, that when there's a draft opinion that's shared, it stays in the court. But now there's no trust. Everyone is a suspect. It's like the movie Clue, right? Was it Mr. Plum in the library with the wrench, right? Who did it? Every law clerk is now a suspect. Every justice is now a suspect. And there's a cloud that will hover over the court for years to come after this leak. It's absolutely devastating.
If I may add something to all of that, and I completely concur with everyone, I think it's very important to identify up front what we know and don't know about the outcome of the decision. It is virtually impossible at this point. I guess there's a 0.00001 chance that Mississippi doesn't win this case in one way or another, because opinions don't get assigned until the end of conference when there's a vote, and they get assigned to a justice who's in the majority opinion. So the very existence of the draft suggests that the vote was taken. That said, the normal practice is to circulate opinions and see who's going to join it. And there is still a possibility that if you saw the argument, you would appreciate that Chief Justice Roberts is not on board with Justice Alito's draft and will attempt to lure one of the other five. So I think it's important to at least recognize and not give the leaker the satisfaction of believing that we know the outcome here. That said, as I say, there's a 99.5% chance that Mississippi has at least one, but the future of Roe remains somewhat in the balance.
And that leads perfectly into this first question from viewer Ruben, who asks, if the Supreme Court decided this in 1973 and reaffirmed it in 1992, how can changing justices change the interpretation of the Constitution? Professor POWE, I turn it over to you.
Well, the Supreme Court in its interpretations has always said, a prime reason for overruling a case is it was wrong the day it was decided. And that is precisely what Justice Alito's opinion says. And stare decisis of adherence to precedent has much less effect in constitutional decisions because the Constitution is basically unamendable. And therefore, the only institution that can change a wrong interpretation of the Constitution is the Supreme Court. And changes in composition of the court have always preceded changes in results.
Well, that leads into the next question, which comes from Zane. Professor Blackman, he asks, upon what basis can the court justify restricting our freedoms?
I think we have to be careful. What is freedom? What is liberty? Right? The Constitution does not define what freedom is. The 14th Amendment speaks of liberty in the abstract. In Roe, the court said that the word liberty includes the right to abortion. And in this draft opinion, the court says liberty does not include this abortion. The effect of this decision is not to actually restrict liberty directly, but to give the power to the states to decide what laws to enact. So I think it's a mistake to think the court is restricting liberty. What the court's saying is now the states have the latitude, perhaps, to restrict abortions.
I want to jump to Professor Rambo to answer this next question. It comes from David. He says, if SCOTUS is going to send everything back to the states to decide, does that make the court obsolete?
And I think the answer to that is absolutely not. I mean, if nothing else, the Supreme Court decides an awful lot about the Constitution that does not involve individual rights. You have questions of federal government power. You also have rights that we hold against the federal government. And while there are some indications that some of this opinion could be used in the context of other recognized constitutional rights, I think we're a long way off from a wholesale abandonment of rights by the Supreme Court of the United States. So it's definitely something to look for and look at. And I do think that there are seeds, justices plant seeds and opinions for taking the court and the Constitution in the direction that they want it. And some of those are there. But we're a long way off from their being able to do that successfully and rendering the Supreme Court obsolete.
Something Professor Poe touched on was that a change in the makeup of the court often precedes a change in opinions like this. But something that Molly touched on, she asked a question, were the recent vaccine and mask mandates the gateway to allowing government control over human life? So I guess she's asking if there's kind of another impetus here. Professor Chandler, did you have any thoughts on that?
Yeah, I would say clearly not. That is, the Supreme Court's decisions on masking mandates and the like is somewhat of a mixed bag. And there are differences in the way it's treated restrictions from the federal government and ways it's treated restrictions from the state government. But to the extent that the Supreme Court basically said that individuals had certain liberties to be mask-free, clearly that doesn't seem to extend to rights of pregnancy. And I would say really, although of course the two issues are related, there are definite significant distinctions between mask mandates and whether someone has to carry a child to term and under what circumstances.
So sticking with you, Professor Chandler, one of the other questions we saw come up over and over again was about what happens now. And James asked, could Congress simply pass a law legalizing abortion and President Biden sign it into law?
Right. I think that's the big question going forward, which is there's actually a bill on the floor, the Women's Health Protection Act, which purports to codify, to make a statute out of Roe versus Wade. And the question is going to be, does Congress in fact have the power to pass such a statute, and where does that come from? And indeed, if you read the draft opinion on pages 10 through 11, there's this curious passage in it where Justice Alito seems to try to shut that down in advance by saying that there wouldn't be any sort of equal protection claim, which would lead for my constitutional law nerds out there to start wondering about the Commerce Clause and whether the Commerce Clause gives Congress the power to permit abortions and prohibit state action. That's a knotty question. We also have the question, what if Congress goes the other way? What if Congress starts to restrict abortions? Does Congress have the power to do that? So I think there are going to be we're not done with constitutional law. We're not done with the Supreme Court by any means. We're just going to be having a new chapter if this draft opinion, in fact, becomes the real opinion.
Professor Blackman, did you want to add to that?
I think going forward, we'll see another area for litigation. For example, could Texas make it a crime for a person to leave the state and get an abortion? Could Texas make it a crime for a Texas organization to fund an out-of-state abortion? So let's say Uber or Amazon pays for a Texas employee's a travel to go to California to get an abortion, right? Could Texas criminalize that act? I think we'll see litigation in other areas about the breadth or the scope of one state's power to impose restrictions on abortion in other states. So I think Professor Rambo was exactly right. A decision overruling Roe doesn't get the courts out of the business of abortion cases. It simply shifts to very different kind of cases. But what will be settled is that the decision to ban abortion in a single state is the prerogative of the state in the first instance. What happens in other states will now be up for grabs.
Moving forward with the idea that the draft opinion does reflect what the Supreme Court, its final decision. We had a TikTok user ask, what about the same-sex cases that are referenced in the opinion? Can the opinion also impact those? And I'll start with you, Professor Blackman.
Well, I think the gay marriage ruling on its face is not really at issue here. Justice Alito wrote in this draft opinion that abortion is different, that abortion involves a taking of the life of another. Whereas with gay marriage, there's no life being taken of another. So I think you could at least on face value carve out abortion and separate it from gay marriage and other issues. But look, the justices can sort of do what they want. And if the court overrules Roe today, other issues in the chopping block, what I think it's unlikely is that there's no march on Washington to overrule gay marriage cases. There's no march on Washington to overrule contraception cases. There's been a 50-year campaign to overrule Roe. I think the political will is simply absent for these other issues. I think abortion is really an issue unto itself, and that's why the court is where it seems to be, at least as of February.
Professor Poe, do you think there are any implications for other cases hinted at in this opinion?
There could be. I think what Professor Blackman said was absolutely correct in all its particulars. But the justices could go at same-sex marriage. I don't think so. There's such a national consensus about same-sex marriage that it just wouldn't make sense to go at it. And there's never been a full national consensus on abortion.
Professor Chandler, did you have thoughts on this one?
Yeah, I agree with most of what's been said. The only qualification is that if you did a cut and paste or a search and replace on Justice Alito's draft opinion, and you took out Roe and you substituted Obergefell, which is the case on gay marriage, or Lawrence versus Texas, which is the case on sodomy, it reads pretty much the same. That is, a lot of it is an assault on unenumerated rights, rights that aren't explicitly stated in the Constitution, for which history doesn't provide strong precedents. And so, although the court says, oh, we're not touching gay marriage, we're not touching contraception, you read some chunks of the opinion and you ask yourself, well, why not?
I like what he said about, how he characterized it, that a lot of people see it as an assault on unenumerated rights. And there's no question, as I mentioned before, that I think there are seeds planted in that opinion. But one of the things that I find that the general public doesn't really get is that there are huge numbers of unenumerated rights that have been recognized by the Supreme Court of the United States. People think that they have a free speech right and that that's enumerated, but you know what? That's only enumerated against the federal government. It's implied and unenumerated with respect to state governments. The same is true with established religion. The same is true of all the Bill of rights, none of those are expressly held against state governments. So I think it's important for the public to realize that when there's talk about an assault on unenumerated rights, it cuts way broader than they generally perceive. You know, Miranda, for example, is an unenumerated right because it comes against the states, at least as to the states, it comes through to the states through the due process clause of the 14th Amendment. And the 14th Amendment doesn't say anything at all about Miranda rights. And indeed, even the Bill of Rights doesn't talk about Miranda. So I just really want to emphasize that it would take an awful lot and it would reverse almost, I mean, an enormous swath of Supreme Court jurisprudence to start really focusing on getting rid of unenumerated rights.
One of the questions that we've gotten, like more than any other related to this, is questions about the legality of leaking this opinion. So John asked, can the person who leaked it be held legally accountable for doing so? Professor Poe?
It probably depends on who leaked it. If a justice leaked it, the answer is no. If a law clerk leaked it and you could find out who did it, the law clerk would be fired on the spot. If an employee of the court leaked it, then it might be theft of government property, and that could be prosecuted. But the better answer of all this is we're never going to discover who leaked it.
Ooh, I suspect we're going to find that out. So
I do too. I think so too.
I'll make you an even odds bet, Professor Poe, that we're going to figure out who leaked this.
I think so
it took for Deep Throat to come out, it took 25 years.
Yeah, that was before electronic trails.
Mm-hmm.
I know a lot of people will be watching it closely. Sorry, Professor Rambo.
One of the things about this is that we haven't talked about is that everybody who works at the court, I believe, and I don't know the extent of the employees' agreements, but every law clerk is now required, since several years back when a book was written by a former law clerk, to sign extremely serious confidentiality agreements. So there's not any question at all that the law clerks and the justices, for that matter, know that this is wrong and this will lead to serious consequences. It would not surprise me if those agreements, and I haven't looked at one, include recognition of the fact that the opinions are government property, as Professor Poe, I think it mentioned. So at a minimum, I think if this is a lawyer, there is a serious potential here for disbarment. This is an attack on the foundation of our judicial system on some level. It's the highest court in the land. Everybody, swears an oath to uphold the Constitution of the United States. And the bottom line is the Supreme Court is the final arbiter on that. It cannot be understated what an enormous ethical breach this is. And I think there are many, many state bars that would share that view. So whether or not it ends up being criminally prosecuted, if they find out who did it, as theft of property, if the person's somebody licensed by the bar, I would suggest that they are in huge trouble.
That does it for the viewer questions, but I did want to ask for your final thoughts. Anything we didn't touch on here that you think is important for folks to know as they're seeing these headlines, which obviously will continue for days and weeks to come? I'll start with you, Professor Rambo.
Well, I'm the only woman on this panel. So I think it's kind of appropriate for me to say that the potential for this decision is to, I think, most of American women, a tragedy. That's a political position, and I mean no disrespect to people who feel differently. but I do think that that's the main reaction. You know, I didn't include this in my first thought, but my first thought was that it was someone who was so extremely upset they couldn't control themselves and leaked it. You know, like anything else, with some more thought put into it and figuring out the political dynamics, I came to feel differently. And these women are coming to me and asking, how can this be happening? Much like, you know, many of your questioners are. But it's very important to understand that the Supreme Court has the power to recognize individual rights, and just as it has the power to recognize individual rights, it has the power to retrench. And that's what we're seeing. But again, it's not eliminating abortion, it's sending the efforts to the political battleground in each state. And those who support a woman's right to terminate her pregnancy need to get very, very busy pushing state legislation and, frankly, changing their neighbors' minds.
Professor Rambo, thank you. Professor POWE, final thoughts.
This would not have happened without Mitch McConnell. His decision to not hold hearings on Merrick Garland when Justice Scalia dies in February of 2016 allowed Justice Gorsuch to get on the court, and McConnell's decision to ram through the Justice Barrett nomination when Justice Ginsburg dies 46 days before the election. Without Mitch McConnell, this one wouldn't have happened.
Thank you, Professor POWE. And finally, Professor Chandler.
Yeah, what strikes me the most is that what had been a somewhat abstract debate about the nature of rights is about to become very, very real on the ground. As I mentioned, within 30 days of that Supreme Court decision coming down, abortions will essentially be a felony in Texas, whether we're dealing with a 4-week-old fetus, a 20-week-old fetus, whether the fetus is deformed in some fashion, and you will see doctors, I think, coming to a screeching halt in not providing it. Neighboring states are also clamping down on abortions, and so the ability to get one's going to be difficult. What that's going to mean is, and maybe it's for good, maybe it's for ill, is that the issue is going to be thrust quite vigorously into the political arena. And if people are unhappy with the pretty draconian restrictions that are being placed on abortion by our legislatures, they're going to have to fight, and fight hard, in those legislatures to get those decisions overturned. And it now won't be a matter of just two abstract ideas about constitutional law. It'll be a matter of the fate of individuals, or if you're on the other side, the fate of babies or things that are close to babies. And so, for better or worse, the Supreme Court is doing exactly what it said for a long time it was thinking of doing, which was to putting this back into the hands of the states and the people.
Professor Blackman had to jump off because of a time constraint, but I wanted to thank the three of you for being a part of this discussion. I think it shed a lot of light on some of the issues at play here and answered some very common questions that we've had from viewers. So thank you so much.
Thank you.
Thank you.
If you're interested in learning more, KHOU 11 has complete coverage. Just go to khou.com.